Hi friends, meet a lawyer who passed in 1987 from CLC, Delhi University and has cross-examined more than 10,000 witnesses, Mr. Rakesh K. Sharma. Sir, please tell us something about you.
In fact, 1987 I passed out from CLC and it's been more than 3 decades. And cross examination was something I always loved. And I was always allured to cross examination because of my interest to bring out the facts before the court which were not visible. So that was the basic reason of my attraction to the cross examination.
Sir, please let us know what is cross-examination and how is it relevant?
In fact, cross examination, I would like to call it cross examinology. Cross examinology is a branch of science where one has to articulate the questions to weigh or outweigh the truthfulness or veracity of a witness. So, in a way, I understand that cross examination is a tool to decide at end who is going to win or lose. So maybe this is a tool which you can call as a shovel. This shovel is very helpful to bring out the facts before the court. And if I go that in a case there are three important phases. One, the pleading. Pleading is the portion where we are going to make draftings. Second is the cross examination. Third is the presentation at the final argument. All the three are very important and actually helps to understand the possibility of a case. Who is going to win out of that? But of the three, cross examination is the most crucial and important of three.
How do you suggest lawyers to coin the strategy of cross-examination?
Yes, a very interesting way to understand what to do and how to do. It is really very crucial that the person, the lawyer who is going to cross examine, should frame a clear strategy for a particular witness. And in a way, I'll call that cross examination is a two-edged blade. So it has to be cautiously used. Either you are going to cut the other party's case or your own case. So better do not cross examine unless you have a clear strategy in place. And to my understanding, strategy of cross examination depends on 3 points. First, know how the witness is trying to prove or disapprove something. Second, you should know your precise facts and the defense of the case. If you are not clear what are your precise facts or what is your defense, it will be dangerous. Third would be the knowledge, the answers you want from the witness. If you are not sure what answers you are looking, probably it will be a failure. So have knowledge on all the three aspects, and of course, a good strategy is always based upon good knowledge.
Sir, looking into your such a vast experience, please give some tips to the budding lawyers.
In fact, when we talk about the cross examination, one do not get a chance to make mistakes and then learn out of the mistakes. So the best way to learn cross examination is not to make mistakes but learn from the mistakes others made. However, there are few points which I would love to stress. For example, the number one, that we should always start cross examination in a lighter mood. Then probably the second point which I'll insist upon is that do not intimidate or confuse the witness but track the witness. So if we are going to confuse the witness or intimidate, probably he will shirk from giving the answers you are looking for. So put questions in a simple way and track the witness. Then third, maybe you should not rush the questions. Try to build questions from the answers or the expected answers. Then fourth would be something you must have the exact fixed points which you are looking to get from the witness. So, in a way, instead of just dragging on the cross examination, try to look out what I want from the witness. And the fifth would be that we should always confront witness with the contradictions so as to shake their confidence off, or in a way we should be doing so while using the precise and relevant questions. Then probably the next point I'll insist upon, that you should not ask questions in a manner of continuity. For example, you should change the line of cross examination. I remember an incident that probably there was a shop in one case and the witness was claiming to be in possession of the shop. And I had asked him in the beginning of the cross examination that were you having all the keys of the shutter of the shop? To which he replied yes. And then I changed the line of cross examination, and after an hour or so, when I asked him that did he got the key of the central lock of the shutter, the witness was unsure. So he answered that probably he was not having that key. So smartly, I could show that he was not having all the keys of the shutter. So such changing the line of cross examination and coming back is always helpful to the lawyer. Another instance I remember, that there was a crime, that was a criminal case, and the witness who was saying that he was there at the spot when the crime had happened, and subsequently also he said I had gone twice over there assisting the police in the investigation. Now when that was a part of the examination in chief, in cross examination I asked him that did you notice that there was a CCTV at the spot or not? Now this shaken the witness and he said he didn't notice if there was CCTV or not. Then I asked him that how many times did you visit over there? His answer was very simple, that I had gone there only once. So he contradicted his own statement by saying that I had been there thrice. So the cross examination has to be in such a way that we have to bring out the facts from the witness, place them before the court to show the credibility of the witness. Similarly, another important thing, probably I'll say, generally lawyers believe that we should ask the leading questions. But I would say generally do not ask leading questions in cross examination, but ask your questions in such a manner that you lead witness to the answer you are looking for. Of course, next point I'll insist, the eighth one, probably you can say leading questions you can ask, but those have to be asked only to contradict or to make suggestions. Sometime while putting a leading question, we harm our case. So one has to be very careful. Then the ninth point, I'll say that put your more questions based on the facts or relevant facts. You should base your cross examination on important facts. And of course, the 10th one, I'll say do not cross examine witness on the law points, because we have to confine to the facts. So keep away from the law points. Then the next point I'll say that if you find a witness is evasive of your answers, make a request to the court, have rest of the cross examination in the pattern of question and answers, so that your questions are before the court. Whatever answer witness gives, let the court understand. Then of course, the next point I'll say that you should frame small and precise questions. It should not be a lengthy or a task which is going to confuse. And of course, never put questions which will go against your defense. Always remember what is your case, so that when you ask a question, do not destroy your case. So these are just few points I'll say which lawyers must understand and use. Of course, there is a big list, but I think these are sufficient.
Sir, what's the law on cross examination? Please tell us something about it.
The law of cross examination is based upon, to my understanding, first the need to understand the law. But of course, when we talk about the law of cross examination, it's largely based or codified in Chapter 10 of the Indian Evidence Act, which runs from Section 135 to Section 166. This actually encompasses the entire paraphernalia of the cross examination, but of course, Criminal Procedure Code as well as the Civil Procedure Code also discusses bit about it. But before I go to the law of cross examination, how we understand it from the law or the case or certain facts as laid down in different acts are crucial. So, primarily, we need to understand the law we are going to deal. Say, for example, when I say that I'm dealing a case connecting specific relief act, so I need to know the law on which I am harping. Similarly, if I am hitting a case into an Indian Penal Code, so I need to know that. But if we go to the cross examination, Chapter 7 of the Indian Evidence Act 1872 lays down very clearly that there is a burden of proof. This burden of proof lies to one side, either to the prosecution or to the accused, either to the plaintiff side or to the defendant side. This burden of proof is very important, and we need not enter into cross examination in respect of the points which the other party has failed to discharge their onus. So when prosecution was to prove that accused at a particular time was present at a particular spot, but the prosecution has not discharged their onus, so we should be cautious while touching these points. When we talk about the law on cross examination, probably chapter 10 has clearly laid down the entire framework of the cross examination. For instance, if I say section 137 defines the cross examination, what is it? The examination of a witness by the adverse party. So what is cross examination is very simple. But while understanding cross examination or getting into the law, probably we have to understand beyond chapter 10. For example, though it's nowhere defined, I, to my understanding, had always understood witnesses and classified them into two parts. One, the witnesses which are formal in nature. Two, the witnesses which are important. And when I talk about the formal witnesses, section 139 in a way gives its illustration while saying that the witnesses summoned to produce documents cannot be cross-examined. This is what is being said in section 139. So I'll call them the formal witnesses. But at a time when a witness has brought a record, and we have to ensure that witness had all the rights to bring that evidence or that record in the court, and we have to ensure that that witness has brought the record which was called upon. Sometimes the witnesses, now probably this is an electronic era, so section 65B had been an important part. So they bring the copies. So even if they brought a copy of the record, so we have to ensure that record is correct, not just as per the section 65B, but also as per the record which was available in their office. For instance, section 141, it says that probably gives the power to the lawyers that you can ask the leading questions. So this chapter totally deals with the law. But law on cross examination is something which is very small. But of course, how we use it as a shovel in our hand, whether in the criminal cases or in the civil cases or in any other type of litigation. So being a somebody as a trial attorney, I have learned lot in last 3 decades, and I would always love that lawyers should gain not from the positivities but also from the errors. Thank you very much. It's been nice. Thank you.
Thank you, sir. We shall have more such an informative interviews on cross examination. Subscribe and like on our channel so as not to miss them. Thank you.